Before we jump into today's courtroom drama, here's the situation. A zoning violation turns into a tense legal showdown when a property owner claims she never received notice of a citation. But the township insists they followed every legal step required. What happens when someone says they didn't know about a court case, but the court records say otherwise? And more importantly, does that claim hold up legally when a default judgment has already been entered? In this case, the judge must decide whether to reopen the entire matter or let the ruling stand. Stick around, because this hearing quickly reveals just how strict courts can be when it comes to procedure, notice, and responsibility.
Good morning. Today is February 26th. We're ready to start our day. Judge Pattison has the arraignments today, so I have a very light morning docket. I had a personal protection order matter that was scheduled a little later this morning. I understand that's off. We have one zoning violation matter set for 9 o'clock. Then I have just a very light docket this afternoon, and
Right away, you can tell this isn't expected to be a major courtroom battle. The judge even describes the day as light, which usually means routine procedural matters. But sometimes those routine hearings end up revealing deeper conflicts. Zoning disputes, in particular, can escalate quickly because they involve property rights, community standards, and enforcement authority. In many cases like this one, the real legal question isn't even about the property itself. It's about procedure. Did the government follow the proper steps? Was the defendant notified? And if a judgment already happened because someone didn't respond, the only way to reopen the case is through a motion to set aside a default. That's exactly what's about to unfold here.
Are set for 9 o'clock. Then I have just a very light docket this afternoon, and at 3 o'clock this afternoon, I'm going to do the wedding for Deputy Frank Metz. He asked me if I would do his wedding ceremony, and I was honored to do it. So I'm looking forward to that. That'll be at 3 o'clock. So it's actually all in all a pretty light day. I have a meeting at lunchtime and a couple things this afternoon. Judge Pattison took on one of the bench warrants. Today's first lyric is really easy.
Moments like this are interesting because they humanize the courtroom environment. Judges often deal with extremely serious legal matters, but they're also part of the community. Performing a wedding ceremony for a deputy later in the day shows that this same courtroom can host life-changing legal moments of very different kinds. But that calm atmosphere is about to shift. The case that's about to start involves a zoning violation, and as we'll see, the property owner and the township have very different versions of what actually happened regarding notification and responsibility.
I have just a very light docket this afternoon, and at 3 o'clock this afternoon, I'm going to do the wedding for Deputy Frank Metz. He asked me if I would do his wedding ceremony, and I was honored to do it. So I'm looking forward to that. That'll be at 3 o'clock. So it's actually all in all a pretty light day. I have a meeting at lunchtime and a couple things this afternoon. Judge Pattison took on one of the bench warrants. Today's first lyric is really easy, but it's all part of our shared humanity, rock and roll poetry. This song's 55 years old, but I've quoted it more than a few times. Came into my head this morning as today's first line. They've paved paradise, put up a parking lot with a pink hotel, a boutique, and a swinging hot spot. Don't always seem to go, but you don't know what you got till it's gone. That song is just as true today as it was 55 years ago. They're still paving paradise and putting up parking lots. Well, I'm very sorry to hear about Marquette. Good morning, U.S. Postal Service retired. Hope everybody's weather is better, even if you do live in Marquette. Spring is coming. Just read a book set in the Upper Peninsula. In paradise. He was all over the northern Michigan.
Many courts now broadcast proceedings online to improve transparency and public access. But once the case begins, everything shifts into official legal procedure. And in today's hearing, that procedure will become crucial because the entire dispute revolves around whether proper legal notice was given.
Well, I'm sorry to hear that. I did get a couple of nice emails this morning. BJ wrote a song. I think he might have had some AI help, but it's pretty good lyrics. So thank you for that. Got another nice email yesterday afternoon from Billy, and hope everybody in Key West is about where we left them. Yes, paved paradise, put up a parking lot, might be apropos for zoning. I don't know if it is for this one, but we'll share that, give it a listen, and remember when you heard it when you were young. I mentioned this yesterday. The yesterday first lyric was Warren Zevon's song, sung by Linda Ronstadt. The people at the Linda Ronstadt tribute concert I was at were all a bunch of old people, and they all were ready to, I guess, dance like old people dance, but they remembered these songs from 50 years ago when they were 20 or 25. Or that's one thing music does. It's a time capsule. It puts us in a time and place when we first heard it. Yes, Counting Crows did that song, several others. Amy Grant. The Counting Crows version is good. Yes, thank you. All right, we'll see who's here. I'm going to go ahead and get ready to address our 9 o'clock matter. Thank you for saying good morning. As I indicated, our PPO was off at 10. Have a meeting at noon. I missed something earlier this week. Jim's birthday. He was 39 on the 20th. So happy birthday to him. I hope your snow is melting. They pay paradise, put up a parking lot. More importantly, you don't know what you got till it's gone. Good morning.
Good morning, Judge Middleton.
Here's where things start getting interesting. The hearing is scheduled for 9 o'clock, but the defendant, the person asking the court to undo the judgment, isn't present yet. In court, punctuality matters a lot more than people realize. If you're the one asking for relief from the court, showing up late immediately weakens your position. Judges expect the moving party, the person requesting the motion, to demonstrate seriousness and preparation. Even a few minutes delay can subtly affect the tone of the hearing. The judge decides to wait briefly, but he also makes it clear that the court will proceed if necessary.
All right, we've got everybody we need except Miss Keenan. It is 9 o'clock. Well, let's see whether they're here yet. Hello, Deputy Myers. Any sign of Rosalind Keenan yet? All right, we have a zoning matter at 9. All right, thank you. If she does come, please usher her right into the courtroom. Thank you. Bye. Good morning, everyone. We are set to address White Pigeon Township versus Rosalind Keenan, except Rosalind Keenan isn't here yet. Andrew Kreiber is here on behalf of the township, and Jason Trosper, the zoning enforcement officer, new zoning enforcement officer for White Pigeon Township. Mr. Trosper, be careful what you ask for, because you just might get it. So you inherited Doug Kuhlman's mantle, and there's often a lot of difficult cases that come with that. So we'll just sit here for a minute. It's not unlike Ms. Keenan to show up not exactly on time. So let me put you both in the waiting room. I have a live stream on, so it's pretty boring to just watch me sit here, but I don't want to talk about the case at all without her being present. So don't go away.
Okay.
Sounds good. Thank you, Your Honor.
All right. What?
Jason, what's his last name?
Trosper.
Trosper, okay. So it's
He's kind of famous. All right, we're gonna wait just a few minutes, and if she doesn't show up, we're gonna make a record.
Now the defendant finally appears, but only by phone, not by video. That may seem like a small detail, but in court proceedings, it can matter a lot. Judges often prefer video because they can observe body language, review exhibits together, and ensure clear communication. Phone-only participation can make hearings more complicated, especially when documents or evidence are involved. In fact, you'll notice the judge immediately expresses concern about reviewing exhibits. That's small. Technical limitation can make an already difficult motion even harder to argue effectively.
All right, we'll do the best we can. I don't like doing it by telephone only, particularly if we're going to be looking at exhibits.
Okay. See if I can try to. Can David try to get through to you on his phone real quick, because he has an iPhone?
Yes.
Okay. Should I hang up and call you back then in a minute?
Well, you can leave this connection up if David's going to do it on his phone.
Okay, go ahead. Thank you.
He's here by phone. Her son's gonna see if he can get a Zoom connection.
Thank you for having patience.
Looks like it. I can't log into my old Zoom meeting account. Let me try one more password. US. I am trying this, and it looks like I'm not going to be able to get on here.
Again.
This
All
is the
right,
key
well,
legal
let's
moment
do
where
the
the
best
judge
we can.
outlines the procedural background. The defendant received a citation in July 2025 related to a nuisance ordinance. When someone doesn't respond to a citation or court notice, the court can issue, let's call it a default judgment. That means the case is essentially decided because one side failed to participate. But the law does allow a way to challenge that outcome. The defendant must file a motion to set aside the default, and they must prove two things. First, a good reason for not responding, and second, something called a meritorious defense, meaning they actually have a legitimate argument that could change the outcome.
Gordon, Reese, Scully, and Mansukani of Bloomfield Hills. And Jason Trosper is the zoning enforcement officer for White Pigeon. The defendant got a citation. This is some, see the best I can determine here. There are some issues. This is defendant's motion to set aside the default. And so that isn't a end all or be all. If the motion's set aside, then we just start from scratch. But here's what I know. The defendant received a citation on July 10th of 2025. And the address on the citation is 2129 McKinley Avenue, Mishawaka, Michigan. And it was for a parcel on Dowagiac Road in White Pigeon Township. Doesn't have an address. It was a nuisance ordinance. Letter sent to property owner on 1/21/25 by certified mail, returned as unclaimed. Violations are still present. So that was issued on July 10th of 2025. Now, I guess it was sent to the McKinley Avenue address in Mishawaka. I don't have a proof of service. The plea by mail was sent by the court to Rosalind Ray Keenan at 2129 McKinley Avenue, Mishawaka, Indiana. And that was sent, what's the date on that? It's 9/12/25. The defendant did not respond, and the judgment entered by default. Defendant has moved to set aside the default. She contends that the address listed on the judgment, and I didn't see this anywhere, was 5955 West Main Street, Kalamazoo. I don't think that's right. Defendant contends that her current address is 68906 Wallowa Road, White Pigeon. That's the address that's on the court file, and we'd had that address previously. I think her son, Mr. Zambrano's address is the Mishawaka address. Anyway, Ms. Keenan, you did a pretty good job of this. You filed a motion to set aside the default. You have an affidavit of your alleged meritorious defense. So let's see what we got here. First of all, before we start to arm wrestle about this, Mr. Kreiber, do you have any objection to the motion to set aside the default and just starting from scratch?
Yes, Your Honor. I believe you stated everything pretty properly. We did file a responsive motion to the motion to set aside default judgment, and there's just a couple things I'd like to address as it relates to that.
It's her motion, so we'll hear from her first, and then we'll hear from you. All right.
And here comes the central argument from the defendant. She claims she was never properly served and didn't know about the citation. That's a serious claim because due process requires notice before legal action can proceed. But there's an important legal distinction the judge will explore: actual notice versus legal notice. Even if someone personally didn't see the paperwork, the law often considers notice valid if the government followed certain official procedures like mailing documents to the address on tax records or posting a notice on the property itself. This distinction often determines whether a default judgment stays or gets overturned.
In January of last year, and then July, and then September. Ms. Keenan, what's your contention?
Well, I was not properly served. I didn't know anything about it. I didn't get a notice.
Where do you presently reside?
Well, I believe I did, trying to look at my dates too here. I don't know what address they had when that happened, but my mailing address was at that address, but I also, the mailings that they were sending also, they sent to, hold up, I got the paper.
Where you currently reside. What's your current address?
I was trying to explain why I was not properly served, and then here, still looking through this. I'm trying to sort out as well, please. I got one of them addresses where they had me send this mail to the.
Well, let me repeat my question.
Okay.
What's your current address?
The current address is 68906 Wallowa Road, White Pigeon, Michigan.
So, all right.
490. Thank you.
Well, they sent it to that address, didn't they? Let's
I don't
look.
think so.
Let's see here. Plea by mail went to the McKinley Avenue address. I guess at some point we changed your address to the Wallowa Road. We'd had that address in the past.
Yeah, when I
So,
went up to file the motions with
all right.
the lady.
Mr. Kreiber, you indicated you filed a responsive pleading. I don't see it. When was it filed?
Your Honor, I believe it was set February 17th is what I have dated here. I want to say we did email it and mail it. I don't know if the court was e-filing. Let me see.
Well, let me see if there's an I was busy on February 17th. Key West email correspondence. But no, we got some correspondence from Mr. Brown indicating he wasn't going to be counsel, but I don't see.
Yeah, it was. I see an email sent to 3bcivil@stjosephcountymichigan.gov from my assistant Fran Beer at 3:26 p.m. on 2/17.
All right. Apparently, somewhere is an email regarding the Rosalind Keenan case from counsel in 3B Civil mailbox. Somebody check that, please. All right. At any rate, Miss Keenan, the property is in White Pigeon Township on Dowagiac Road. I'm not familiar with that road. I thought I knew every road in the county. I was hoping maybe it was on the Cass County side of the line and this would be somebody else's problem. But so that's where the property is located. Is this that same property we dealt with years ago?
That's my understanding, Your Honor.
Yes, it is, Your Honor. It's the same one they tore the building down and
All right.
they
I've
started
owned the
building again.
property since, I don't know who he's asking. I think he was asking me, but sorry about that. I was butting in.
All right. There was some sort of a structure on it that was over by Wallowa Road though, wasn't it? Well, at any rate, let's see what we can figure out. So, Ms. Keenan, your contention is you never got notice of this citation. So there's that first issue. Then the second issue is, do you have a meritorious defense? I haven't seen any pictures of this property for a number of years, and I don't know what current condition it is. Plaintiff filed a responsive pleading, which is lost in cyber limbo somewhere. Did you get a copy of it?
Your Honor.
Now the township's attorney responds, and this is where their legal strategy becomes clear. They argue that service was properly completed through multiple methods, mailing notices to the tax record address, and even posting the citation directly on the property. Posting notice on a property is a common legal method when mail is returned or unclaimed. From the court's perspective, that's often enough to satisfy the legal requirement of notice. So the township's position is simple. The defendant may say she didn't know, but legally, the township did everything required to inform her.
Yes, Your Honor. So thank you, and there's no problem in not having reviewed them previously. But I guess just to give the quick quick summation of this is the service was properly effectuated. We did mail it to the subject properties tax statements, 2129 McKinley. We did also, I don't know if we had necessarily attached this, but we did try to mail it to the 611, another 611 address as well. Those mailings were returned as undelivered, unclaimed. Thereafter, on about July 10th, the citation was also posted on the subject property itself. So it was service was effectuated via posting, if nothing else at the end of the day. Notwithstanding that, Your Honor, I do not have a copy of the meritorious defenses, which Your Honor has already noted as one aspect in the requirement to set aside a default judgment. So I can't really speak as to what the meritorious defenses, meritorious defenses are at this time without knowing what they are, obviously. But that is a requirement that necessarily would need to be established for a default judgment to get set aside.
You mentioned you tried to send it to a 611 address. Are you referring to the Wallowa Road address, 69906?
Let me see, Your Honor. I just had it pulled up a second ago.
That would be 611 South 6th Street in Goshen, Indiana.
Oh, okay.
That is correct. Thank you, Jason.
That would be my old address.
Yeah, we lived there
I
clear
haven't
back
resided there years.
before I even purchased the property. And we moved since.
Notwithstanding the 611, I do believe plaintiff stated earlier that the mailing address on the tax records for the address was the 2129. So that would necessarily be proper to send to, Your Honor.
All right. And it was posted on the property.
That is correct.
That was in July, Mr. Trosper?
Yes, yep, I went out there, I had 3 of the sheriff's department's deputies go out there with me when we posted it. Because we did have threats coming into the township that if we showed up on the property, violence or anger, something would happen to us. Because when Mr. Mixon sent the first letter out about the building going up, so I did have 3 witnesses out there, and then we did have pictures of it where it was posted in front of on a tree in front of the structure that's out there.
And a picture of that is attached as Exhibit B to our response as well, Your Honor. But there are additional pictures which are a little further away and more blurry.
Lapita, would you put that pleading in my on base? I'm also, she refers to the affidavit of meritorious defense, but I don't actually see it.
That is my understanding as well. I know she references it in her motion, which I do have a copy of her motion. I have a copy of her Exhibit A, which is the civil judgment. And I believe she refers to the meritorious defenses as attachment 1, but I have not seen an attachment 1.
Your Honor, I didn't know I had any until the day I filed these papers.
Say that again, please.
I didn't know I had the judgment going on until the day that I filed the papers, and I came up there to the clerks and filed them immediately. Again,
Well,
I don't believe I was properly served,
The
sir.
property where the taxes go is the address for the property. Now, I don't even know if this property has an address. It should, but I don't believe it does. It's just Dowagiac Road. But the owner of the property, who is you, is registered with the taxes at a certain address. That's where they sent it. They actually posted on the property. So you're certainly got a notice of the citation. The question is regarding the plea by mail correspondence that went out from the court. That went to the McKinley address in Mishawaka. And that is apparently the address on the tax parcel. Your son, David Zambrano, lives there. A certified letter was sent to that address and it was refused. And now you claim, well, nobody told me what was going on. And I don't think that's going to carry the day.
Your Honor, my address, that is my mailing address. I actually am in the middle of relocating, so that's not actually where I reside.
We both are. Those
my
are mailing
younger brother
addresses.
named Richard Keenan. He allows me to have mail sent there while I'm currently homeless, and that's the same reason why this was not received on our end, is because my brother's wife and him, they're the ones who receive our mail. So pretty much it's like our mailing address in care of him, and he did throw, or she may have thrown the envelope away or something like that, where we did not receive proper notice.
And I went to the clerks and explained to her.
And there it is, the judge denies the motion. This decision comes down to two major legal failures in the defendant's request. First, the court determined that service was legally sufficient. The notices were mailed to the address connected to the property and posted on the property itself. Second, and this is just as important, the defendant failed to present a meritorious defense. In other words, she didn't explain why the zoning violation claim itself might be wrong. Without both elements, courts rarely reopen default judgments. This ruling keeps the original judgment in place and moves the case toward enforcement.
The default should stand. So your motion to set aside default is denied.
I do.
And the motion to stay enforcement is denied.
Your Honor,
I expect what's coming next, Ms. Keenan, is a request for a compliance order where they're going to request that you remedy the property, or they come in and do it and spread the bill on the taxes. Mr. Kreiber, is that where we're headed?
Yes, Your Honor.
Ms. Keenan, your family's owned this property for some time. What's your intention regarding whatever their allegations are? Do you intend to clean this up, or?
I'm really prepared to answer any questions.
I'm not prepared because I'm just trying to get through to this, that, I wasn't properly served, sir.
You were legally served. You may have not had actual notice. It was posted on the property. They sent it to the address on the tax roll. They aren't clairvoyant. They don't know where you went to.
Sir,
Plus, whether you were properly served or not, you didn't state any meritorious defense. So there's two prongs to the motion to set aside the default. One is due cause for not responding. That would be your lack of actual notice. Secondly, you need to file what's called an affidavit of meritorious defense to show that there's even a reason to set the default aside. But you haven't done that because I don't think there is a meritorious defense. I think the property is in poor condition. So the motion to set aside the default is denied. The motion to stay enforcement is denied. You owe the fine. Mr. Kreiber, do you intend to file for an enforcement order?
Yes, Your Honor. I believe that will be our next filing.
So here's the final takeaway from this courtroom hearing. The judge ruled that the default judgment would not be set aside because two legal requirements were missing. First, the township successfully demonstrated that they followed proper service procedures, mailing notices and posting them on the property. Second, the defendant did not provide a valid meritorious defense explaining why the property shouldn't be considered a nuisance. As a result, the original judgment remains in effect, and the next phase will likely involve a compliance order requiring the property to be cleaned up, or the township may step in and bill the costs through property taxes. Cases like this highlight how critical legal procedure is in court. Even if someone claims they didn't personally receive notice, the law focuses on whether proper legal steps were followed, and now we want to hear from you. Do you think the judge made the right call here, or should the defendant have been given another chance to argue her case? Let us know in the comments below, and if you found this case as shocking and fascinating as we did, make sure to hit that like button, share this video with someone who loves courtroom drama, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.